Okay, the next case to come before the court is State of Ohio v. Jamie Mishler. Each party will have up to 15 minutes to present their arguments. The appellant may reserve up to 5 minutes for rebuttal, and if you do plan to reserve time, please let me know as I'll be keeping track of the time. The arguments are being recorded, so please stay behind the podiums and keep your voices up. You should not use the names of children or minors or victims in your argument. You can refer to those folks by initials or terms like the child. The judges have read your briefs and are ready to proceed when you are, and I would just ask the appellant, would you like to reserve time for rebuttal?
Yes, Your Honor, 5 minutes if necessary.
Very well, then you may begin when you are ready.
Thank you, Your Honors. Joseph Patatus and Catherine Purdom on behalf of Mr. Mishler. This case, I think really the focus is on assignments of error 1 and 2. They are interrelated and interlaced. And in reading the state's brief in comparison to ours, I do know that we couch part of our assignments both in the abuse of discretion standard. But I want to be clear that we are raising a challenge under Cata Lupe, which is a challenge as a matter of law, de novo challenge. And that's how we start off assignment of error number 1. So where it diverges and branches out, in assignment of error number 1, the court's failure to hold or even to consider the motion to suppress based on the standard it used was Schindler. It is an error that this court reviews as a matter of law. There was no factual finding. The abuse of discretion comes into play where the court, and if we look at the docket in this case, the court failed to hold a hearing on the motion to suppress or even the purported issues with the motion to suppress. It denied it within 5 days of filing. The state of Ohio did not even raise an objection to the motion to suppress that was filed in the trial court. The court simply sua sponte acted, and I believe if we look at a calendar, the court struck that motion, denied it within 2 business days of it being filed, giving in this case, the appellant, Mr. Mishler, no opportunity to be heard as to why it may or may not be sufficient. And I think if we look at the motion that was filed, I think plainly it falls in the category of what Cata Lupe stood for. There are 3 general issues that are raised. I have it here. I have the benefit of having it right here in front of me. But then in each subsection underneath, which I think we normally consider to be the memorandum, it points to the specific code section. It points to 4511-19D4, which is the standardized field sobriety test not being conducted within substantial compliance with a national standard, NHTSA, as we often refer to it. And the next section is the breath test. Was the breath test performed in compliance with the Ohio Administrative Code? This was a BAC data master machine, which the Ohio Administrative Code requires very specific things to happen in order to be admissible, and that code section was cited in Mr. Mishler's first motion to suppress. And again, this isn't a situation where the prosecutor showed up with a motion challenging the sufficiency. The prosecutor did not object. So the court essentially stepped into the shoes of the state of Ohio, the city, and said this motion as a matter of law is deficient and therefore it's denied.
Well, I don't think anyone would contest that the motion is pretty much
It's brief.
well, it's brief, but it's also, a form motion. Isn't it? I mean, it's everything that possibly could happen under the sun to challenge a suppression issue is mentioned there. The accused this, the motion to suppress.
In the first motion or the second motion, Your Honor?
Well, tell me, what's the date of the first motion?
The first motion I have March 15th, 2022.
Yes, that's the one I'm looking at too.
In the motion that I'm looking at, I would respectfully, I would disagree. I would say that we have 7 sub-statements or subparts that are raised in our, I know it's not part of the record. Actually, we could look at the motion that was filed in May. That was a 34-page motion that went into incredible detail. That was one that I would say is essentially everything under the sun that happened in the case. This one, it may or may not be a form. I'm not familiar with the attorney's, this attorney's, how he files his motions to suppress it. This isn't how mine look when I file them. Mm-hmm. But what Cata Lupe says, and Cata Lupe addresses that, because in Schindler, I believe Schindler was the form filing that was bounced. It said that was insufficient as a matter of law. And I think in Schindler, it was simple statements like, Any statement of the defendant has to be struck, field sobriety tests have to be denied, and then it just ended. I think it was even more sparse than this. Guadalupe had less than what's here. So if we look at Guadalupe, the Supreme Court lays out the challenges there. That was a one-page motion to suppress. Again, this is admittedly bare bones, but the test isn't whether or not the attorney files with 1 page or 50 pages. The test is the state of Ohio on sufficient notice of what the allegations being raised are?
And that's what I was getting at in regard to being a form motion. There's nothing in here specifically dealing with the facts of this case, right? I guess it's just statements taken or made by the accused. No lawful cause to stop the accused. Officers request field sobriety test. Then it gets into, that the test of alcohol did not, the administering of the accused test of alcohol did not conduct the test in accordance. Some of these may not even be relevant to this case. It just sounds like there's a list of everything that could possibly be raised in a DUI case or suppression.
I absolutely understand what you're asking. We have the benefit, though, of having the transcript that came out of the trial, and we can see that as we go through the motion to suppress, it does actually line up. And if we look at paragraphs 12 and 15 in Guadalupe does not require any facts to be placed into a motion to suppress. There is no requirement that case-specific facts be placed in a motion to suppress. It's just whether or not there are case-specific issues to give the state of Ohio the chance to respond.
And how does this give, I guess the point is, this is kind of like an indictment where the defendant,
Excuse me.
that's okay, where the defendant would ask for a bill of particulars, because what the heck are you talking about?
Sure, and I think that was, so, I do think under Guadalupe, that's where the court, it's not an abuse of discretion. As a matter of law, the court got this wrong. But with what the court's asking now, that's where the state of Ohio has the opportunity to step in and say, hey, I don't understand that. Because we have nothing in the record to indicate what the state's actual position on this was. The state could have looked at this and said, my review of the discovery, as the transcript shows us, is Mr. Mishler made a statement. They want to suppress that statement. Because this is a case where the officer who saw the infraction isn't actually the officer who pulled over Mr. Mishler, which goes into no reasonable cause or to stop the vehicle. Because if Officer 1 is the officer who saw the infraction, but Officer 2 is the one who effectuated the stop, as is the case here, because there was issues of snow, there was issue, if you remember from the transcript, of was that double yellow line actually crossed? So the prosecutor looking at this never raised an objection and said, Your Honor, I don't understand what's going on here.
So the prosecutor was just supposed to call every possible witness that was available for this case, for the suppression hearing?
And I think that's a fair question. I think what the prosecutor, we don't know what the prosecutor should have done. I would say the prosecutor would have had the opportunity to object and say, I don't believe this is sufficient. And in this case, there was 3 witnesses that would have been relevant to the case. There's the 2 arresting officers, the officer, the lieutenant, I believe it was, who was transporting somebody, and then the officer who conducted the field sobriety test. So there's 2 there for the investigation, and then the breath test officer. So I don't know that that's a huge burden on the state, but the state could have objected. If
Well,
the state found,
I'm sorry for interrupting,
no,
but
please.
is there case law that says the prosecution has to object, or is there case law that says that the defendant has to make a proper motion to suppress?
There's both.
Okay.
So first, when we look at Guadalupe, Guadalupe says, again, in paragraphs 12 and 15, there was less than this filed in Guadalupe. And the
But it's not about, I agree with your statement, it's not about the brevity of it or the length of it, it's the notice that's presented. So you can put somebody on notice with 2 lines sometimes, and sometimes you can have 15 pages that doesn't put somebody on notice.
I guess when I look at this from my practice, I do not look at this as being, it may be a form pleading in the sense of somebody just cut and paste from one motion to another, but my form motion to suppress that our firm starts with, I know it's not part of the record, but since we're kind of talking about forms that's outside the record, I have over 100 areas that we focus on. But we tailor it specifically to the case. We raise.
Let's come back into the.
Right, coming back into this record, I do not believe this is a form filing that's insufficient to place the government on notice.
Was your first filing within the 35 days for pretrial motion?
This first filing is, yes.
And it was on the very last day, right?
I believe it was on the very last day. Which then gets me into the abuse of discretion part of the argument, is that the court never conducted a hearing, there was no notice, it was essentially denied within 2 days, 2 business days. When the defense came around, and I went to law school to avoid math, I believe it was about 45 days, please don't hold that against me, it was in May. So this was in March, and then in May, Mr. Mishler files his, what I would describe as being an exhaustive motion to suppress that was also instantly denied. There was no hearing held on that, and the ruling, and I believe the basis for it was that motion was filed outside of the 35 days. In that area, that exchange right there, I believe, is outside of anything that I could find in either this district or any sister district on how the court is supposed to.
Counsel, you're moving into your rebuttal time.
Just very briefly then, I could not find anything that could be instructive here where somebody timely files a motion within the time. That motion is struck for being a Schindler motion rather than a Guadalupe motion. And then I couldn't find anything on what the remedy is when they later file.
Was there ever a leave filed?
He did. He filed, if you look at the docket, the attorney first filed a motion for leave, and then the way it's docketed, you see motion for leave, and then you see the brief that's filed right after. And in his motion for leave, he did indicate that he had to go back through. He became aware that the motion was struck. He needed to go back through and supplement to fix what the court saw as the errors, and the court then said, too bad, you're out of time. So I think that was an abuse of discretion. The attorney did meet what he was being asked to do. Thank you.
Very well. You will have 4 minutes and 6 seconds when you get back to it.
Thank you.
Good morning.
Good morning.
May it please the court, my name is Megan Philbin. I represent the appellee of the state of Ohio in this appeal. I'm a prosecutor for the city of Medina. So this appeal arose after Mr. Mishler was found guilty at jury trial for operating a vehicle under the influence of alcohol, under the A1A section, and also under being over the legal limit under the A1D section as well. So I'm just going to go through assignments of error in order. So the first assignment of error, that's where we're talking about that first motion to suppress that was filed by Mr. Mishler. So initially he files this boilerplate motion, which just generally identifies a multitude of suppression issues that could be raised in basically any OVI case. He did not include in there a memorandum or something that would identify specific issues that were specific to his case. So any like fact pattern, usually we would see some kind of memorandum attached to these motions to suppress, where it would say, on this day, Mr. Mishler was operating his vehicle, and it was in the city of Medina, and he was, stopped for this offense, and this is why this is an issue. So it's initial detention. The issue is because, like Mr. Patituch had said this morning, in his motions to suppress, he may put in there, it was a snowy day, something like that along those lines. That was not included in this motion to suppress. That was initially filed by Mr. Mishler. This motion did not have the particularity that was required to put the state on notice of any irregularities in that OVI investigation and arrest. So the trial court had denied that motion to suppress based on his failure to identify the suppression issues with specific facts related to his case, and the state's position is the standard review of this issue is abuse of discretion. Now, abuse of discretion is more than just an error of judgment, but instead demonstrates perversity of will, passion, prejudice, impartiality, or moral delinquency.
Why is it not an issue of law? I assume you're still talking about the original motion to suppress and not the motion for leave to file a motion to suppress.
So why is it an issue of law?
Yeah, I thought that under Guadalupe there, I don't know if I pronounced it right, that it was an issue of law. Either sufficient or it's not.
Well, so it's our position that we believe that the Xenia case is what, Xenia versus Wallace is the case that would control this issue and not necessarily the Guadalupe case. So it's our position that that specific case is what the standard would be in reviewing this issue. And in that case, it said that the trial court is required to hold a hearing only when the claims are supported by factual allegations which would justify relief. Here we don't have those factual allegations that are actually listed in the motion to suppress.
Okay, well then, what about the motion for filing leave to file a motion to suppress?
Okay, so in the second assignment error, I think that's where we're going. In the second assignment error, he does file this second motion to suppress that is actually filed 66 days later. And this is amended motion to suppress in Stanter. And the criminal rules permit in Stanter motion to suppress when good cause is shown. So the trial court found that he did not include good cause for why this motion should be accepted in Stanter or out of
So
time.
was there an actual request for leave? Because that's what the court has to give you permission to file that motion.
I believe, as Mr. Pettish said, there was some,
There's a motion for leave and then
the motion in Stanter was,
with the motion for leave.
I believe they both were filed together, Your Honor. But he's not provided any cause or reason behind it being out of time in this amended motion to suppress. So they deny it because it was untimely, and I just want to say that there are a few things that Mr. Mishler could have done to have prevented this issue. So first, he could have filed a motion to suppress that had included the specificity that was included in the second motion to suppress. So that's one part where he could have avoided this issue. Secondly, if he was not prepared on the 35th day to file his motion to suppress with all this information, he could file an extension, and that's freely given in this trial court. He could have done that. Or if he didn't do those first two things, which was the case here, he could have filed this out-of-time motion to suppress, but just indicated to the court, hey, this is why it took me so long to get this filed here, because it was 66 days after the first motion to suppress. So it's not like it was denied and then the first motion to suppress was denied, he got the notice, in the mail, it took him a couple of weeks, it was 66 days later. So that's a substantial lapse of time. So it's our position that the trial court did not get this wrong because of the substantial amount of time that had lapsed and the failure of Mr. Mishler to detail why this was good cause after the fact, after he had missed the deadline. So it's our position for both of the first assignment of error and the second assignment of error that these are not an abuse of discretion by the trial court, and each of those errors should be denied.
Did the defendant waive his right to a speedy trial in this case?
I'm not certain, Your Honor. So the third assignment of error we have in this case, and I had a little bit of difficult time understanding necessarily what was being argued in this assignment of error. So the appellant indicates that the trial court erred in permitting the state of Ohio to introduce evidence of field sobriety test where the state of Ohio failed to establish substantial compliance for the field sobriety test. So I think he's arguing that the state should have been required to establish substantial compliance with NHTSA manual during the jury trial, And it's my understanding that this issue is something that is solely to be raised during the motion to suppress, does not prevent the state of Ohio from bringing in the evidence of the standardized field sobriety test during the trial. And so he fails to file a valid motion to suppress because we get through the first two issues. And then Mr. Mishler also is arguing, I think at the same time, that the state of Ohio should have submitted into evidence the NHTSA manual as well. State of Ohio is not familiar with any requirement of the state of Ohio to present a NHTSA manual at a jury trial. I haven't been able to find anything on that issue. I don't believe that's a requirement of the state of Ohio to, as like a prerequisite to be able to have the standardized field sobriety test in the record for a jury trial. Also, I think that Mr. Mishler had failed to even raise this issue when we're in the jury trial, and because of that, the only argument left on that issue would be plain error, and he also has not raised that on appeal here today. So this assignment of error should also be denied. Now, there's two more assignments there. Assignment number 4 is that the trial counsel's performance was deficient to the point that it rendered the assistance ineffective and affected the outcome of the trial in violation of defense Sixth Amendment rights. So in order for there to be ineffective assistance of counsel, the standard review on this issue is to establish that he's ineffective must show deficient performance by counsel, the performance falling below an objective standard of reasonable representation, 2, prejudice as well, a reasonable probability that but for counsel's errors, the proceedings would have been different. So here, I think the main contention that Mr. Mishler had in his filing was that the trial counsel did not object at certain points where Officer Hughes was testifying. I believe there were certain misstatements when he was testifying to the NHTSA standards for the standardized field sobriety tests. And I believe, I want to say that, so his failure to object to those statements, but also failure to cross-examine him effectively on those statements as well. It's our position that Officer Hughes, he did testify during the trial, but also we have, in the city of Medina Police Department, we have all of our officers have body camera now. So, and this was played on video for the jurors. So not only do they hear Officer Hughes testify, but they're also able to see exactly what he did during the time of the trial. So we get his instructions for the SFSTs, we get his demonstration, we get the defendant's performance of the SFSTs. If there was any deficiency in what Officer Hughes was testifying to, it didn't match up, the jurors could see it themselves in the video that they watched. And what that video did show was he did comply with the NHTSA manual and those standards when he administered these tests properly. So it's the state's position this assignment of error should also be denied. The final assignment of error that we have here is a sufficiency of evidence error. And here it's the standard is whether a conviction is supported by sufficient evidence. It's a question of law that the court is to review de novo. And I'm just going to go through what the trial itself showed. So I know Mr. Patitucci he argued that there were only 3 witnesses, I believe, at the trial. That's incorrect. So we actually have, there were 3 officers at the scene who testified, and then we also have 1 additional officer who testified at the station. So we have Sergeant Crooks was the initial officer who noted Mr. Mishler's operation of his vehicle. He notes that Mr. Mishler is weaving in his lane, traveling left of center, and this was caught on dash camera and played for the jury. Now, Sergeant Crooks was transporting another transport to the jail, so he was not able to personally stop Mr. Mishler, so he calls it in to another officer. Sergeant Lynn from the Medina Police Department also follows behind Mr. Mishler. She also sees Mr. Mishler committing marked lanes violations as well. So we have 2 officers that see his driving behavior. We also have Sergeant Lynn, she stops the vehicle. She notes a strong odor of alcoholic beverage coming from Mr. Mishler's breath, and she also notes that he spoke in a thick tongue. She was the officer that was in charge at the time and supervising the other officers on the road, so she could not necessarily get into an OVI investigation herself. So then this gets handed off to a 3rd officer. So it's Officer Hughes, and he's the one who does the primary investigation of the OVI at the scene. So Sergeant Hughes testifies, he too smelled that odor of alcoholic beverage. He also noted a thick, slurred speech that Mr. Mishler had, and he performed the SFSTs with Mr. Mishler. I also want to note that in his discussions with Mr. Mishler also indicated that yes, he had been consuming alcohol. He had, I believe it was 2 IPAs that the officer recognized the brand, knew that they were stronger IPAs. This launched into the performance of the standardized field sobriety test. So Officer Hughes testified to how these tests are performed, how he did actually perform them, and we also saw those on video. I'm not going to go into all of the SFSTs and things like that, but on the horizontal gaze nystagmus, he did see 6 out of 6 clues. That's what he testified to. He saw 4 out of 8 clues as well, and on the walk and turn, and also 2 out of 4 clues on the one-leg stand. So at the conclusion of Officer Hughes' testimony of what had happened, we get the next officer who testified is Officer Shears from the Montville Police Department. He then testifies. That's our witness number 4, and he was the officer who actually did the breath test with Mr. Mishler. And Mr. Mishler's breath test result was 0.108 grams of alcohol per 210 liters of breath. So there's substantial evidence that was presented to the jury in the form of the officer's testimony, also the physical evidence that was played for them with the body camera, the dash camera, and the evidence of the breath test results. So it's the state's position that substantial evidence was presented to the jury, that they could reasonably conclude that these essential elements were satisfied for the crimes that he was charged with. And so the state respectfully requests that each and every one of these assignments of error be denied. Thank you.
Thank you, counsel. And you will have just over 4 minutes for your rebuttal.
It's chapter 3. First, to answer the court's question, Mr. Mishler appeared, entered a plea of not guilty, waived time. As to the leave to plead, the leave to plead was filed on May 16, 2022. And he did set forth the reasons in his leave to plead as to why he was asking for more time. I don't have the docket number, but it's just because it's too small to read, but it was filed on May 16, 2022. when
When-
we,
Let me take some of your minutes here.
no,
When the judge denied the leave to plead or the motion to file the motion to suppress in Stanner, the court said that it was untimely. Did the court get into no reasons were given? I haven't been able to pull up the court's entry yet.
in full candor, it was a longer decision. The main thrust that I recall is it was untimely, that it had to be filed within 35 days. I recall the 7 days in the interest of justice part being bolded and underlined. From my review of, that's just one thing that sticks out, and I recall the court finding that there was no in the interest of justice reason stated, which when I read the leave to file, the defense attorney is laying out that I'm filing this now because my prior motion was filed without a hearing. I want to put you, Your Honor, on record of what the full filing would be. And you're right to ask a question.
I was gonna ask a question when you're ready.
Go ahead. Go ahead.
So it sounds like maybe the judge had a policy that if you asked for an enlargement of time before the 35 days, then you would be granted that very easily, but if you asked for it post 35 days,
I would,
I don't know if
I
you
don't
know
want
the
to
answer
speak
to that
to,
question. but-
I don't know that the
Because
answer to
it's,
that question.
I guess the question, we're talking about being arbitrary or not.
Right.
If you ask before 35 days, you get it, but as long as you need it, but if you don't, you're
Well,
out.
It's not in the record. I know that it's not as long as you need. Normally, I think, in my experience, it's only been either 10 to 14 days. I can't speak for what happened here, and I don't know if there's a local, I don't believe there's a local rule that addresses that. There may be that I am failing to cite. Going back to the questions that were asked regarding the form filing, I would ask, well, first, it is not an abuse of discretion standard. The Supreme Court, in overruling, I know it was this court, in overruling this court, said this court erred in applying an abuse of discretion standard.
For leave to plead?
I'm sorry, for assignment of error number 1, for the filing of the first motion to suppress, the Schindler style motion. In paragraph 7, the Supreme Court of Ohio very directly says the abuse of discretion standard in this case is not appropriate. When we look at, and it starts in paragraph 12 of that decision, and we compare the motion to suppress that was filed, that Guadalupe said, the Supreme Court said was sufficient, and it says there is no reason the state of Ohio was not on notice. If we compare the two side by side, this one has more. We just read through paragraph 12, through paragraph 13.
But couldn't more be the problem? What if you had two legal issues instead of 7?
Well, I think here they're specific, because if we look at the legal issues, I'll just pick one at random. Number 4, the test where, the breath test was involuntarily taken because of threat. It doesn't say any and all threats. It says specifically the threat of loss of its license under the implied consent law. When we look at number 5, the individual administering the test didn't do so within the time limitations and the specific requirements of, and it cites to the specific machine type. So it doesn't say any and all breath test. It says so it's tailoring it into the facts of this case. And when we look at what was filed in Guadalupe simply said any and all evidence following the unlawful traffic stop, any and all evidence obtained from the state by the fruit of the unconstitutional arrest, any and all observations and field sobriety tests. Like, that's far more broad and general than what Mr. Mishler raised in his challenge here. That's a tongue twister.
And counsel, I'm gonna have to ask you to wrap up.
Thank you, Your Honor. I would ask this court to follow the authority of the Supreme Court, find that the original motion to suppress was timely filed and it was appropriately filed, that the state of Ohio was on notice, and that the court did abuse its discretion after, and I think this is the important part too. If we want to say that that first motion was deficient, that the court should have had a hearing to hear out what was going on and then allow leave to file. Thank you.
Thank you. Thank you both for your presentations. The court will take the matter under advisement and issue a decision in due course. The clerk of courts will mail a copy of that decision to you on the day that it is released, and it will also be posted on the Ohio Supreme Court website. Thank you again.